Sergio, you got anything to say before we get started?
No, buddy. We should bring our guest on. Very relevant topic, actually. I mean, I don't know how many of our audience members do Amazon Flex. I know a couple do, but the issue is not about that. It's about the gig economy in general. So let's bring him on and talk about a very important subject. Stephen, welcome.
Good afternoon. Thanks for having me on.
Absolutely. Yeah. I mean, this is very timely. So there's a Fortune article out there that I read, and I kind of acquainted myself with what you do and what the situation is. And obviously, we do read it in the news, daily that the, flex drivers are trying to unionize and this and that. There's a headline pretty much on a daily basis regarding the gig economy. I mean, gig economy is not just Amazon Flex, but at the moment, you are involved with Amazon Flex and drivers. So go ahead and introduce yourself and tell us a little bit about your law firm and all that good stuff.
Sure. My name is Stephen Tindall. I'm a partner at the Gibbs Law Group, and I've been an employment lawyer for 27 years, basically my whole career. I started at two other firms, but in all three of my firms, I specialize in representing large numbers of employees bringing cases against their employers for breaking the law. And a few years ago, it's probably been 4 or 5 years ago now, our firm started wading into the gig economy cases. And Amazon Flex is a huge part of that right now. We've also represented Lyft drivers and Doordash drivers, Instacart, and Postmates. So we've done all of those cases. Currently, what's most active is our Amazon Flex cases, as you mentioned.
Okay. Let's talk a little bit about that specifically. So what are the Amazon Flex arbitrations about? What is this case about? Is it also a class action? Is it not? So, give us the breakdown on that.
Certainly. So our Amazon Flex cases, we have filed as arbitrations. And as most of the people who are part of the Rideshare Guy know, you often sign an arbitration agreement when you sign up with Lyft and with Doordash and with Amazon Flex, which requires you, if you're going to bring a claim against the company, to do it in arbitration. Part of that agreement is what's called a class action waiver. And there's a lot of litigation about whether those are valid or not. They have been, in general, upheld to be valid, although there's fights in cases like Amazon Flex where you're delivering things across state lines, whether those apply. But the tack we've taken is we've filed individual arbitrations. So far, we've filed on behalf of over 15,000 Amazon Flex drivers. It's 15,500 and change, I believe, is the number to date. And we have additional clients, about 10,000 additional clients that we hope to be filing relatively soon on top of that 15,000. And these claims are ones that your viewers may be familiar with. They're claiming that under the state laws of California, Illinois, and Massachusetts, so those are the three states that we're focusing on, that these drivers should be treated as employees, but they're treated as independent contractors. And as a result of that, there's a number of protections that employees get under these states laws that Amazon is not providing to the flex drivers, including minimum wage for all hours that they work, overtime for when you drive more than 40 hours a week, or in California, this is really important for the flex drivers. When you drive 7 days in a row, there's also overtime. And certainly around the holidays, a number of our clients do that. And probably the biggest ticket item is expenses, reimbursement of expenses. And this usually comes down to sort of mileage that you're driving, but also cell phone. We've recovered cell phone charges as well. But all of these things are protections that employees enjoy in these states, but Amazon doesn't provide them because, as I said, they treat all of these drivers as independent contractors.
Yeah, there could be some sort of an overlap though in this. It just doesn't have to be Amazon Flex, because I mean, you're talking the typical gig worker, right? You're talking an average Uber driver, Lyft driver.
Yep.
I mean, our audience is mostly rideshare drivers, obviously, but this has been going on since the inception of these companies, right? I mean, they have to have us as independent contractors, and they passed something called Prop 22 in California, and now Prop 32, I call it, in Massachusetts, but Couldn't any of this be applicable? By the way, when you said, you talked about there's terms of service that they push amendments on us continuously, pretty much once a month or so. Obviously, it's all legal mumbo jumbo. I mean, I happen to read all 28, 30 pages of it like an idiot, but because we want to find out, right, to opt out of certain things that it's our right to opt out, right? Not just to go to arbitration, but in this case, it seems like you're just dealing with arbitration cases.
Our firm is just doing arbitration cases. You're right that this doesn't just apply to Amazon Flex. In fact, the cases we brought on behalf of Lyft drivers, on behalf of Doordash and Postmates and Instacart drivers were all basically the same claims. They were all misclassification as independent contractors, seeking reimbursement of expenses, seeking minimum wage, overtime. There's some statutory claims on top of that as well.
Yeah. Yeah. So a couple other things that comes to mind is that obviously you said 15,000 or 500, 15,500, and you're expecting 10,000 more. So the question is, how soon should someone start who's doing Amazon Flex? I mean, we do have gig workers obviously all over the country, but this is, you said, in how many states? 3 states so far?
3 different states, correct. California, Massachusetts, and Illinois.
Okay, so people, I mean, there's like a few hundred of you watching here. If you know anybody that's Amazon Flex, or you may be doing it, because we suggest to everybody to multi-app, right? I mean, just don't get stuck with one app. Just do Uber, Lyft, Amazon, DoorDash, whatever it is. If you are doing Amazon Flex, Stephen is your man for those cases anyway. And so the question is, how soon should they do it? If they're doing Amazon, does it matter if they're doing 5 hours a week, 10 hours a week, whatever it is?
That's a very good question. And the short answer is, if you're interested in asserting your claims, the sooner the better. And the reason for that, and your viewers and your members may know this, that every legal claim has what's called a statute of limitations. Statute of limitations just means there's a certain period of time in which you can bring a claim, and beyond that time you can't. So for most of California, it's a 4-year statute. For Illinois and Massachusetts, I think it's a 2 or 3 year statute. So it means that if you file today, you can only go back that length of time. And so if you've been driving for 2, 3, 4 years, the longer you wait, the smaller your damages are going to be, because each day that you wait is a day that you won't be able to recover, if that makes sense.
Yeah, it makes sense. Of course. Yeah. I mean, pay attention to this, please, folks. If watching now and watching later, the sooner the better. Obviously, Stephen and his info and his law firm's info is in the show notes. Please pay attention to it and just go click on it, and then it'll directly take you to a portal where you can apply for these things. Another question comes to mind is that a lot of drivers are nervous about coming forward, right? Because this is their livelihood, right? Do you know if Amazon will retaliate by, we call it deactivation, but I call it firing, but it's called deactivation.
Right. No, we understand that, and we understand the concern. Our experience in Amazon Flex has been that despite Amazon knowing that we represent these 15,000 people, we've not heard of anyone who's been deactivated as a result of asserting their rights, has been fired essentially for asserting their rights. Amazon's counsel is very smart. They're very careful, and they know that if they were to sort of mass fire or mass deactivate people who have asserted claims, it looks really bad. It looks bad to a court. It looks bad to an arbitrator, that they're discriminating against people for asserting their rights, which under California law and Massachusetts law and Illinois law, it's illegal in all of those states. Is it possible that it could happen? Yes, but they would be, in addition to breaking the law with regard to misclassification, they'd also be breaking the law with regard to the deactivation.
Yeah, absolutely. So, a lot of our drivers obviously will come, they'll ask you, we'll answer as many questions as we can, but if they do have questions, I'm sure they'll get in touch with you after the episode. A lot of them are going to probably send me emails and ask me, how much can I recover? What's the past been like, or what's the results have been like, right? Obviously, past results is not a guarantee of the future, but Can you give us a little bit of a clue about what they should expect, and what they should expect as far as the process is concerned?
Right. Yeah. Well, you took the words out of my mouth about past results not predicting future results, because lawyers are careful people. We don't want to say that you will certainly recover, or you'll certainly recover a certain amount. What you can recover relates directly, in our experience, relates directly to the number of deliveries you've made, the amount of time you've spent. So it's not just like a lump sum that everybody gets. It's more, if you make more deliveries for Amazon, for each mile that you drive, you should be recovering the IRS rate at least. That's 55 to 65 cents, depending on when you were driving per mile. So the longer you drive, the more that adds up. Similarly, if you're working overtime, Amazon Flex does not pay overtime ever. They never have. And so all of those hours in California, over 8 in a day, or in 7 days a week, or over 40 in a week. So for the drivers who are driving a lot, they recovered not only the reimbursement of expenses, but also for the time you spent driving that you weren't paid for. And so we've had 9 of our cases have gone all the way through to arbitration, and we've been very successful. In 8 of the 9, the arbitrator has found that they were misclassified as independent contractors. And so that doesn't mean we will continue with that level of success, but we believe that we're right on the law. And so we're confident about that. And 7 of our 9 have recovered damages. And it depends, like I said, it depends on the length of, some of them were on the lower side because they'd only been driving for, 5-6 months. Some of them are on the higher side, which was like 3-4 year drivers.
Yeah. Yeah. The other thing that comes to mind is that, I always knew that, don't ask a question you know the answer to, but then this is the time to ask those questions, because our audience is probably interested in all of this stuff. So they should start a claim soon, right? And as far as the timeline for the cases you said that you settled, from 8 out of 9 in a successful fashion, how long of a process was that? Because as rideshare drivers, we're not a patient bunch.
I know. And it isn't, I mean, just to correct your terminology a little bit, those weren't settlements. Those were rulings by an arbitrator.
Okay.
In my other gig cases, we actually reached settlements in Instacart and Lyft, et cetera. But in these cases, Amazon has not been in a hurry to settle cases. So we've had to actually take them to it. Once the process starts, it depends on the arbitrator. Some arbitrators, it's kind of like the Wild West. When you sign into an arbitration, when you sign an arbitration agreement, you are not, you're bypassing the court system, and you're signing up with an arbitrator. In theory, it's a quicker process than in court. In practice, sometimes it is, sometimes it's not. And it depends a bit on how the arbitrator proceeds in their cases. Some of them want to move quickly, and they get it moving, and they say, all right, how quickly can you put this on? Some of them allow both sides to get as much information as possible. And, oh, you need more time? That's totally fine with me. And so it really does vary. I mean, it can be, several months to a couple of years is what I'd say.
Okay. The other thing is, obviously arbitration, has its costs, right? I mean, arbitrator needs to get paid and all that. But what is the cost if a driver watches this and signs up with your law firm? Like, do they incur any costs? What let us know about that.
That's a great question. My law firm does these cases entirely on a contingent basis, which means that the drivers don't have to pay anything unless we win, and unless we win and get a recovery. So if we win and we get a recovery, then we recover the out-of-pocket expenses that we've spent for like depositions, or for paying for transcripts, or things like that, and as well as a percentage of what it is that they recover. But if it's not successful, then they don't have to pay anything.
Okay. As we know, we use our cars, right, as our tools of the trade. Yeah, I've done Amazon Flex actually, but not too much, because I didn't like, doing 80 deliveries in like 2 hours and carrying bottles of cases of water, whatever. But I still drive, but I'd rather do rideshare. But during the, these deliveries, I mean, a lot of people get into crashes. It's obvious. I mean, the more you drive, the likelihood it is. So do these cases involve, if a driver gets injured on the job, are those kind of claims included in these, or this is completely separate?
There's sort of, let me unpack the question into two different things. One is sort of damage to the car. And if the car is damaged while you're driving, there's good case law, at least in one of the states and maybe in all three of the states, that suggests that that is a work-related expense. And so just like gas, just like wear and tear, that's a work-related expense that an employer, if you were properly classified as an employee, that an employer needs to reimburse you for. Personal injury aspects of it, that's not part of what we do. That falls under the sort of heading of workers' comp. And workers' comp, there are great workers' comp lawyers out there in all three of these states. And so what we would do is we'd recommend, look, if you're injured, we'll put you in touch with a good workers' comp lawyer that we trust, and that you can pursue that part of it, and it shouldn't have an effect on your misclassification case.
Okay. So I've asked pretty much what I could think of to you, and I'll give you the floor for the last few minutes. Summarize what you do for people who join late, and also, give us some advice. I mean, I think a lot of our audience is going to send me emails now and say, hey, how about Uber? How about Lyft? I feel like I'm their employee because they're algorithmically discriminating against me, doing this, doing that. I mean, look, we've done all this for the last 3 years. We've proven it a million times, but I'm sure the day is going to come that there is going to be massive arbitration cases as far as rideshare is concerned too. So we'll keep you in mind, obviously, but floor is yours. Go ahead and, close us up.
Yeah, certainly. So if you are an Amazon Flex driver, I strongly encourage you to get in touch with us. I think the website where you can get in touch with us will be provided, especially if you're in California, Illinois, or Massachusetts. Right now, those are the only 3 states we're doing. That has to do with the law in those states being very clear about the misclassification. That doesn't mean if you're not in those states that you don't have a claim. You very well might, but we're not pursuing. My firm is not pursuing those. So that's number one. Number two, on the rideshare issues, yes, I mean those are real claims. Prop 22 in California really does cut into that. And depending on whether the company is abiding by Prop 22 itself, so providing at least a floor for the minimum wage and providing for some compensation for the mileage, they might be able to properly argue that you are properly classified as independent contractor. That depends on how they are treating you. And we haven't lost that argument in Amazon Flex. We haven't really faced it yet. Amazon hasn't raised it. So we'll see what happens with that. But, if you're within California, that's something to keep in mind. But I would encourage you to really investigate whether your rights are being violated and whether it makes sense to assert those rights, because our clients have had good success. And I think we're happy that they contacted us, and we're happy that they sort of stood up for themselves against Amazon.
Well, again, here's Stephen Tindall. Please pass the word around. I know everybody knows somebody who's doing Amazon Flex, obviously. In these 3 states specifically, the link is in the show notes. Please get in touch with them. As you said, the sooner you, claim, the better. If you have any questions, please send them to me. I'll forward them to Stephen. But thank you for coming on. Really, really important subject. Best of luck, and please keep us posted on how it's going.
Will do. And thanks so much for the interest in the issue and for having me on.
Absolutely.
All right. Thanks for watching. That short little clip was from our live stream, Show Me the Money Club, with Sergio and myself, Tuesdays, 6 p.m. Eastern, 3 p.m. Pacific. Make sure you subscribe, turn on all notifications so you get notified when we go live, as well as all of our awesome content. Make sure to check out this video right here, which will take you to the entire live stream, or check out this video right there. All right, drive smart, everyone.